welcome back to Just Liberty, friends, where justice and liberty meet. I'm Alan Reinhardt, president of the Church State Council, here with my co host, Bettina Krause, editor of Liberty Magazine, the oldest and, dare I say, the very best magazine devoted to religious freedom. And together we are trying, I think succeeding partially, to take back liberty from the political extremes. And one of the things we get to talk about from time to time are Supreme Court decisions. And this time, Bettina, we've got a really good decision out of the court and really good guest to talk about it. Why don't you introduce our guest?
We are delighted to have with us today Will Haun, who is Senior Counsel at the Becket Fund for Religious Liberty, and he's also a non-resident fellow at the American Enterprise Institute. And we're talking today, Will, about a case which has caused a lot of celebration.
Yeah, that would be Mahmoud versus Taylor, which is a tremendous victory for the authority of parents to direct their children's religious upbringing.
Yeah, and you were here just a couple of months ago talking to us about the case. We're now on the other side of it. But for those who maybe didn't hear that earlier episode, why don't you just give us in a nutshell what this case was about?
Sure, this case comes out of Montgomery County, Maryland, which is the nation's most religiously diverse county and has over 160,000 students in its public school system. And that information is relevant background because what it shows is that the county's public schools was doing what nearly every other state in the country does, which is it allows parents the opportunity to know what their children are learning and to allow their children to be opted out of instruction that could violate or substantially burden their religious development. And this is particularly important in areas, sensitive areas around things like sexuality and gender. And so in 2022-23 school year, when Montgomery County Public Schools introduced into the curriculum a series of storybooks starting in kindergarten that was meant to introduce things around transgender ideology and sexual orientation issues to small children, in some cases in very explicit ways, many parents sought the ability to know that their kids were reading these books and to opt their children out of it. And for most of that initial school year, the county, as it does with everything else in its curriculum, allowed for opt outs. Then in March of 2023, without any public explanation, the board just pulled the rug out from underneath the parents and said that going forward, we are never going to tell you when these books will be read to your kids, and your kids will be made to read them. And so, even though they can be opted out of all sorts of other things, Valentine's Day, Halloween parties, receiving alternative reading assignments, they must read these books starting in pre-K, and you will never know when that happens. This led many parents, after trying to persuade the Board of Education to restore the county to this consensus position, to bring a lawsuit. A religiously diverse coalition of hundreds of parents stepped up, really just to uphold the right of parents to direct their children's religious upbringing of their children. And it may be amazing to some of your listeners, but it's important to know this, that while this right is, as the Supreme Court has just said, an enduring American tradition and has deep roots in Western law, for the past 50 or so years, most courts in this country have treated that right in a rather truncated way when it comes to public schools. Most courts have said essentially, when you drop your kids off at public schools, you have surrendered your First Amendment rights as a parent. That is no longer the law, and that is a victory to celebrate.
So, I'm at a disadvantage because I haven't actually read the opinion, but how does the court um, apply the First Amendment then to kids in public schools?
Sure. So, as the court says, it's drawing on an enduring American tradition, which is manifested in a number of cases the Supreme Court has had over its history. Most notably, a case involving the Amish from the 1970s called Wisconsin versus Yoder, but also other cases involving Pierce versus Society of Sisters, which dealt with the ability to send your kids to private school or religious school in particular. And then also other cases about parental choice in education. All of these cases may not be known, but all of these cases had religion in the background. They were essentially cases about parents who, for religious reasons, needing to direct their children's religious upbringing, needed to ensure that their educational authority as parents was being upheld. And it is from those precedents that the court rules that yes, when you drop your kids off at public school, you don't surrender your rights as a parent. In fact, what actually happens is that you as a parent still have this authority over their religious upbringing. And so when that is substantially interfered with, that then there needs to be a compelling reason for that. And here the board simply didn't have one. And because of that, they need to provide the parents notice and an opportunity to opt their children out of this instruction.
So the First Amendment, if I may, the First Amendment case that comes to my mind from, when I was a teenager had to do with students wearing black armbands in opposition to the war in Vietnam, which of course was a decision widely applauded by progressives, by liberals, the Tinker case. Did the court draw on any of that jurisprudence as well?
So that's instructive in the sense that it shows that the First Amendment is still applicable inside public schools. One of the more curious arguments throughout the course of this case is that you could be forgiven for thinking that the board was trying to say that their public schools are almost a constitution-free zone. They, of course, wouldn't put it that way. They would add some nuance to that, but when you think about the kind of total plenary authority that they would have over everything that happens to a child without ever being needing to tell your parents, that really does upend the idea that parents and schools are meant to be in a partnership, and that parents and that schools have authority, but they have that authority essentially delegated to them from the parents.
Okay, so this was a 6-3 decision. So there was a dissent, and the dissent made a lot over what was constitutionally significant coercion versus mere exposure to information in the classroom. What were the arguments around this?
Sure. So the claim was that in essentially, unless a child was actually forced to change his religious beliefs, essentially the teacher took the child by the hand and said, "You can't believe this anymore." Unless that were to happen, the board's view was there's just no claim. There's just nothing the parents need to be concerned about here. Uh, I will never forget, hopefully, though, the Chief Justice at oral argument in response to a claim like this saying, is that a realistic concept for a 4-year-old? I mean, as a father of young children myself, I have to say, I mean, this is just not how small children reason. And the age of the children was certainly relevant to the court here because we are talking about pre-K. We're talking about kindergarten. We're talking about first, second, third grade. Uh, these are highly impressionable young children. They implicitly trust their teachers. And the idea that their teachers would have an environment essentially where they are reading books that say, when things are about love, they don't need to make sense, and that people in your family who think otherwise, they just need to have their minds changed. Or if you're in pre-K, we're going to spend time not with reading, writing, and arithmetic, but having you follow a dog who's going through a pride parade and helping you identify lip rings and underwear and things of that nature. This is highly influential and impressionable on young children. And it is because of that that the court said, look, this is substantial interference. And that's really the test here. We don't need to sit around and wait until a child no longer wants to, be raised in the faith of their parents, essentially when the toothpaste comes out of the tube, for there to be a concern for the Constitution. The Constitution prohibits what's called indirect coercion, or the ability to pressure someone or the government to pressure someone to modify their beliefs or abandon their faith. And that is the environment that the school was creating. And that's clear not only from the text of the books themselves, but then also from the instructional guidance that the board was giving its teachers when reading the books. So, for example, if a child in a third grade class, I believe, was to raise his hand and ask, I thought if you're born a boy, you're a boy, and if you're born a girl, you're a girl, The board gave guidance to teachers that said you can answer that question by saying something like, that's hurtful, that's offensive. Only doctors are just making a guess when people are born. Only you really know inside. There were other kinds of condescending, kind of armchair sociology style comments like this throughout the instructional guidance. And that only reinforced that these books were meant to, as one of them says, rewrite the norms around gender and sexuality. And that means that someone other than the parents is in charge of the religious upbringing of their children. That is substantial interference.
So, I'm wondering if the case turned primarily on religion, because as I'm listening again, to a familiar discussion of this case, it takes me back to when I was out of law school in New York, and there was a big controversy then in the New York City public schools about a book called Heather Has Two Mommies, which was a lot milder than the kinds of things that Montgomery County was doing. But, my reaction then is the same as it is today, which is whatever happened to age appropriateness, and the parents don't have to be religious to decide that 4 years old is not when I want to have these conversations with my child about, diversity, sexuality, etcetera.
Well, it's certainly true, and I believe Justice Kagan, although she dissented, made the point in oral argument that there are probably a lot of secular parents that weren't thrilled about these kinds of things going into the curriculum, and it is true that the age of the children played a role here. But I think religion plays a particular underscores the seriousness of the objection here, because when forming someone in religious duties, you're really forming them for something that transcends and goes beyond the power of the state. It goes outside the power of if the state is concerned about what makes a good citizen, for example, um, forming someone for religious duties goes beyond that. And so it really kind of speaks to the ability of parents to have that kind of retained authority in a discreet way. And then also, to your point, I mean, Montgomery County recognized this implicitly by having a very broad religious accommodation policy that they only changed midstream during this case. I mean, they allowed for a wide array of religious opt-outs. In fact, their standard was essentially the constitutional standard they were opposing in court. They said anytime your religious beliefs are substantially burdened, you can get an opt-out. That sounds very familiar to those of us who litigate in this space.
It was interesting in oral argument, that there was a big, issue or deal made about the, question of administrative workability, and the fact that, if everyone wants an opt-out for everything, then how is a local school meant to, juggle all of those things? How would you answer that objection?
Well, I think the concern just doesn't reflect the reality on the ground, either in Montgomery County or throughout the country. 47 out of 50 states explicitly have a notice and opt out policy in place on any kind of sexuality style instruction. Another 19 states extend that kind of opt out to anything offensive in a curriculum. Hawaii, the entire state of Hawaii, which has a school district around larger or around the size of Montgomery County, has an even more robust accommodation regime. And then even within Montgomery County itself, the county what has opt-outs for things around English as a second language, things around the IDEA, which is a federal disability related statute. Personalized education is modern public education. We try to tailor it to the student. So this claim that the sky is going to fall is just not borne out by the facts on the ground.
Hearing the objection, I'm reminded of times, for example, in an EEOC conciliation where the HR director says, well, if I accommodate you not to be up on Sabbath, I have to accommodate everybody. And of course, the sky doesn't fall because people don't all of a sudden decide that they want to be Sabbath observers in order to get Saturday off.
Yes, the Supreme Court, I believe, referred that once. The Supreme Court referred to that as the classic rejoinder of bureaucrats throughout history. If I make an exception for you, I have to make an exception for everyone, so no exceptions. I mean, it's a logic that eats itself and really would and it creates a perverse incentive where frankly, the more offensive you make something, the less you have to accommodate people. So that's not a right rule.
Oh, that's a funny way to look at it, isn't it? Yeah, make it more offensive so many people will want out, and you say, "Well, that's too difficult."
Yep, exactly.
So you started off, Will, talking about this idea of parental rights, which isn't, an explicit constitutional right. It's grounded, I guess, in other legal principles. How far does this extend, this parental right idea? How far does it extend beyond religion? So, for instance, could a parent who has objections to the curriculum for other reasons, secular reasons, could they also request opt outs under the precedent that's been established in Mahmood?
Well, I think Mahmoud is particularly focused on the role of parents to direct their children's religious upbringing. And so, one thing to think about there is the other ways in which a child's religious upbringing might be affected by what a school does. There are all sorts of policies that schools have that bear upon a child's day. I mean, think about it, they spend the better part of their waking hours in school that could affect religious upbringing that are um, totally apart from curriculum. But the court also took pains to make clear that this was not a case about challenging the existence of the books in the curriculum. This was not a case about trying to get the county to put a new curriculum into place. The democratic process does have a role to play here, and nobody's questioning that. So this is really, though, about a case about that kind of distinct authority of parents around obligations that are higher than simply being a productive member of society.
So, is there a limiting principle here? I mean, at what point could um, a school say, we'll go this far but no further? For instance, perhaps a parent has an objection to teaching evolution, or some other religion based objection. Is there a limiting principle?
Right. So the court makes clear that substantial interference, which is the standard it's looking at to identify how the government has burdened your direction of your children's religious upbringing, it's going to account for the context in which the burden occurs. So that's going to account for things like the age of the child. It's going to account for things like the nature of the curriculum. There's a whole variety of kind of context focused concerns there. And that also is drawn from Yoder itself. I mean, the case involving the Amish that I mentioned, it mattered in Yoder, for example, that the Amish way of life was just going to be completely disrupted by the fact that you were going to be exposing the child to worldly values. Now, there, the issue really was exposure. But because of the context, exposure was a sufficient burden. But maybe in other contexts, maybe the standard is somewhat different. So there is definitely flexibility there. And then, of course, the government is always free to show a genuinely compelling interest. Trouble for the government is it usually doesn't have one.
Well, but thinking back to some of the, free exercise cases over the years, the cases never really turn on whether the government has established a sufficiently compelling interest. It turns on whether the burden on religion is sufficiently substantial. And, I go back to a series of cases. One of my first amicus briefs was on behalf of a Presbyterian landlady in Chico, California, who refused to rent to an unmarried heterosexual couple, kind of a old-fashioned church lady saying, "Well, I would be participating in their sin of cohabiting while unmarried." And meanwhile, the state of California operated a Chico State University in that town and offered, you guessed it, married student housing that unmarried couples were not eligible for, but they cracked down on her, and the Supreme Court of California ruled, well, it was not a substantial burden to impose the housing discrimination rules on on her religion. She could sell her units and invest her money somewhere else, which to me sounds like a pretty substantial burden. But that's kind of where I think these courts, wiggle out of this if they choose to. There's lots of wiggle room in what constitutes a substantial burden, don't you think?
Well, I think the court has done a good job in more recent years in trying to focus the burden inquiry. And I think this case is an example of that because you are certainly right that in the public school context, since Yoder until Mahmoud, these cases were almost entirely resolved on the grounds of burden, that this wasn't a real burden. It wasn't cognizable was usually the word that courts would use because they were looking for, as one court, the First Circuit put it, direct coercion. Essentially, they were actually looking for the child to be forced to change his religious beliefs. But the Supreme Court has made clear that the protections of the Free Exercise Clause are protecting against a kind of hindering of free exercise or an infringing of religious exercise, which isn't just the actual like forcing you to change your religious beliefs, but also the pressure to modify your beliefs. And here, public schools are a kind of uniquely coercive environment. The child is in there for 6 to 8 hours a day. They are around authority figures that, especially when they're young, they are going to implicitly trust and probably accept verbatim what they say. Um, they have the imprimatur of the parents. Remember the whole logic of in loco parentis, in lieu of the parents. And so they exercise enormous pressure authority over children, and that matters a lot when you think about the nature of what the parents still have to show for a burden.
This next question is for the legal nerds out there who have been watching the fate of a case called Employment Division versus Smith, the 1990 decision, which has been at the forefront of a lot of litigation around First Amendment issues since then. So the court in Mahmood declined to overrule Smith. Can you tell us what the Smith principle is and how far it was actually eroded by the
Sure,
decision of Mahmood?
sure. So Employment Division versus Smith, as you mentioned, is a case that many people, I think incorrectly, but still consider the baseline of the free exercise clause as protections. And what it essentially stands for is that if the government is neutral, I'm using my quotes here, neutral toward your religion, and whatever its regulation is occurs in a generally applicable way, then the free exercise clause just doesn't mandate any kind of accommodation. Uh, that has been a standard that the court has increasingly walked away from precisely because of all of the ways in which the government is so rarely neutral and generally applicable when it goes about its regulating activity. The interesting thing about Mahmood is that the court, while it didn't overrule Employment Division versus Smith because it didn't have to, it said very clearly that Smith doesn't apply in the public school context. That there is no obligation of parents making a religious exercise claim to show that the school was not neutral or not generally applicable in the burden that it imposed on the parents. And so, in the public school context, Smith is just inapplicable to parental free exercise claims. It's interesting to think about this for a minute because there are now two contexts where the Supreme Court has unequivocally said that Smith is inapplicable. Smith is inapplicable in the context of what's called church autonomy. So, the authority of religious institutions to make internal decisions affecting their faith and mission. This normally comes up in the context of being able to select your key leaders or your what is known in the law as ministers. Um, the Supreme Court has been very clear that Smith is not governing that set of protections. And then it's also now not applicable in the public school context. This is interesting because if you think about the nature of the free exercise claims in both of these contexts, one involves religious institutions, you could broadly say the church, and then the other involves the family. So, two societies that are outside the state in some ways now don't have to go through this game of thinking that religious liberty is a matter of the state granting you a permission slip. But they actually are, they have their own sense of existence and being, which I think is very important for understanding the right relationship of state power and religion.
Well, following up on this topic, it strikes me that in earlier discussions of Smith by the court, there was concern about, well, if we get rid of Smith, what do we replace it with? And when it comes to church autonomy, it's been replaced by pretty much a blanket rule that the courts stay out of it. When it comes to the public schools, it sounds like the court went back to kind of pre-Smith strict scrutiny analysis, substantial burden, compelling state interest, sort of strict scrutiny approach, which some justices were not entirely in favor of as the way to replace Smith. What the court's likely to do in other contexts is going to be very interesting. One of the other areas right now that is very much in play is the extent to which courts are willing to uphold employers' decisions that religious applicants for vaccine exemption were since based on sincere religious beliefs, and whether the courts are going to, you know, uh, how closely courts want to scrutinize people's religious beliefs. But that, I think, relates very much to the notion of substantial burden because, of course, you have to have a religious belief to be burdened in the first place.
That's true. I mean, I will say, I think Mahmoud also shows us that this isn't your grandfather's compelling interest test, which is to say that things have changed a little bit since the 1960s in terms of how this test is done. The compelling interest test is much more focused on, it needs to be a compelling interest that's to the person. It's got to have other kinds of constraints around the nature of state power, and then the least restrictive means or narrow tailoring part of the test as well has also been tightened up essentially to look for, as the case we also had at Becket, the Fulton case for Catholic social services, so long as the government can accommodate religion in some other way, that's what it must do. So a lot of the concern around the compelling interest test has historically been, look, this is kind of a subjective, open-ended inquiry, but I think the court has done a lot in recent years to really focus those inquiries, and the embrace around history and tradition, I think, is another example of that.
I'm wondering if we can go back to where we started, which was the story of the parents who were involved in this case. I mean, we've been talking a lot of legal theory, but this involved real life families who had, deep concerns. Can you tell us how they have received the verdict? How did they react?
No, they're ecstatic. They're so grateful because these are first of all, these are their kids and these are their schools. And from the very beginning, what our clients wanted was simply just to stand up for their kids, and they want a community that allows them to be a part of it in the same way. And they saw public schooling as a partnership, and they saw this really as a rupture in that partnership, and they wanted that partnership to kind of have the groundwork laid for it again. And so there's been nothing but gratitude and excitement, which is a really encouraging story and development.
Well, thank you so much for being with us today, for sharing your insights into what is a really significant development in religious liberty law. Thanks for being with us.
It's my pleasure. Thank you.
So, Alan, what struck me most about this case was that there was already a common sense solution to all of this. I mean, simply allow the opt out system to continue to operate as it had done for many years before. And yet, the fact that that common sense solution was taken off the table, to me, that speaks volumes about the undercurrents of this case. the fact that there was a desire to really bring to a head sort of this standoff between two very different understandings of how young children should be taught about human sexuality.
I have two kind of different thoughts and different, very different uh, ideas about this case, Bettina. First is just how intolerant and illiberal the progressives can be, right? Because this is, those who want to indoctrinate kids with gender diversity and, LGBT sort of dogmas, not wanting to be tolerant of the fact that people have traditional views about gender, about sexuality, and they want, my way or the highway, which is contrary to the values of a liberal democracy. So they may claim to be liberal, but in fact they're illiberal. And of course that creates the backlash. So that's one obvious takeaway for me. The other takeaway from a legal standpoint is, why is it that parental rights have more clout if it's based on religion? Why isn't it more of a general, "Hey, I'm the parent, and I don't need a religious reason to decide if talking to my 4-year-old about, you know, Heather has 2 mommies or, whatever, if this is age appropriate, I'm the parent. I get to make those decisions, and it shouldn't matter what my religion is, but it matters more if it's religion, and it may not matter at all if it's not religion based. And I guess a corollary of that is that the conservatives are very hostile to the penumbra, as the Supreme Court said, rights that aren't nailed down in the Constitution, like the right to privacy. um I just I see a lot of irony in how selective the court is when it comes to protecting rights. So those are kind of my two takeaways from this story.
I think you're right, Ellen, that this whole idea of parental rights is really unformed as yet. I mean, the court has sort of been tending that direction and trying to sort of make out an outline of this right, of parental rights. But really, we don't yet know the extent of it. We don't really know how it operates in practice. And I think we're only going to see that as more litigation happens in this area, especially when someone brings a non-religious reasons for opting their children out of certain programs. You know, I raised the issue with Will during the interview about administrative workability, and there is a point at which it does become unworkable if all opt-outs are allowed, religious and non-religious. Um, how does a school district maintain any sort of coherency in its curriculum? How does it educate children in a coherent way if you're gonna have children being pulled out of every single class for, a multitude of reasons? I don't know, Alan. I think the decision in this case was absolutely right, absolutely spot on. It had to be decided that way. Um, but I do think there are many more questions around this whole idea of parental rights. How far do they extend into, um, an elementary school, a high school, and so on?
Well, and we didn't even touch the surface on kind of the role and mission of public education in the
True.
first place, and the fact that there has been a concerted assault on public education. You know, when you raise the specter of, well, if everybody gets to opt out, what's left of public education? And I guess what comes to my mind is, if the focus is on what they should be doing, teaching history properly, teaching math, teaching science, etc., um, then there should be an awful lot less of things that are so controversial that parents want to flee.
True, Alan, but even teaching history these days is not without its controversy, right? Social studies, controversial these days.
Well, I'll leave our listeners with this reminder, I think from George Orwell, that he who controls the present controls the past, and he who controls the past controls the future.
On that note, Alan, let's call it quits for this episode of Just Liberty. Thanks for joining us. And until next time, remember, vigilance is the price of liberty.